Hello there, it's AdoLisa Ezeagu. Welcome to today's Masterclass. As you can see, the title of today's presentation is CyberSafe Business, 5 Steps to Safeguarding Your Business, Brand, and Bottom Line. It's really great to have you here. I have a ton of fantastic content for you and a lot of ground to cover. So let's dive right in. This presentation is for anyone who operates a high volume business that handles personal information in any way. That's software as a service companies, financial brokers and dealers, car dealerships, online stores, accounting firms, real estate brokers, insurance brokers, healthcare providers. If your business collects personally identifiable information, this is for you. And if you do collect personal data, this will be the best 45 minutes you've invested in your business in a long time. Today, I'll be sharing some amazing information that will transform the way you do business. And guess what? It has nothing to do with implementing a shiny new piece of technology or software. Instead, it has everything to do with using the right strategy and process. And in the next 45 minutes, I'm going to show you the number one way to prevent data breaches and safeguard your customer and employee information. I'm also going to show you how to gain clarity on your data privacy and cyber compliance requirements without being bogged down with complicated legalese. I'm also going to show you how to transform your business so that all the moving parts comply with the privacy and cybersecurity laws everywhere your business operates. I'm going to also show you how to build a privacy and cybersecurity process that stands up to any regulator, auditor, or other third-party inquiry. We're also going to talk about how to build a cyber-safe business that adds value to your brand and your bottom line. I'm also going to show you how to do all of this even if you are not tech savvy or know nothing about cybersecurity or privacy. So here's my promise to you. In this masterclass, I will give you a step-by-step cyber strategy to safeguard your business. But before we do, I want to first check in to see where you're at. Does any of this sound like you? Do you have a ton of customer data like names, email addresses, passwords, credit card numbers, or even social security numbers, but are not crystal clear on your legal obligations around that data? Do you have a privacy policy on your website, but have no idea what you have to do day to day in your business to live up to it? Do you avoid lucrative business opportunities because you fear the due diligence process and don't want anyone taking a look under the covers of your operations? Does this sound like you? Do you secretly fear an audit and worry about the day regulators will come knocking, wanting to know if you're doing what it takes to safeguard customer data? Do you fear being denied insurance coverage for a data breach because your day-to-day operations really do not live up to what you reported on your insurance application? Or does this sound like you? Are you unsure whether the technology you're using in your business is making you vulnerable to a data breach? Do you hate tech-related stuff and honestly don't want to deal with cybersecurity, but understand that you can get into a heap of trouble if it's not addressed? Are you out of compliance? Are you afraid your business is out of compliance, but don't know how to make things right? If any of that sounds like you, then I have great news for you. None of those things are the real problem. No, they're not. Those are just symptoms. The real problem is that you haven't done what I call the shifts. The shifts are what I've identified as the pieces to a winning cyber strategy. I'm going to share them with you in just a moment. But before I do, I want you to know that once you've made these shifts, there will be no more shooting in the dark. You'll have data privacy and cybersecurity best practices embedded into the fabric of your business. You'll have complete clarity on how to safeguard your business, and finally have the confidence that you really do have your bases covered. You'll finally enjoy peace of mind knowing that even if regulators come knocking, you'll have a documented process showing your reasonable and compliant actions. You'll also know that uncertainty and compliance worry will be a thing of the past. You'll breathe a sigh of relief that your assets are protected using a proven strategy. You'll discover that your business will become more aligned with your original mission, and that's putting your customers first. You'll enjoy the increased market value of having a cyber safe business, not to mention confidence, peace of mind, and the ability to sleep through the night. And if you're in a regulated space like healthcare or financial services, you can certainly appreciate that when it comes to compliance, having peace of mind and an audit trail are priceless. But before we go too much further, let me take a second and introduce myself so you know who I am and why you should even be listening to me. As I mentioned, my name is AdoLisa Ezeagu. I'm a data privacy and cyber risk attorney and certified by the International Association of Privacy Professionals. I help clients large and small prevent data breaches and comply with privacy and cybersecurity laws. I've advised and developed data privacy and cyber risk programs for companies in many different markets, including healthcare, technology, financial services, hospitality, telecommunications, and digital marketing. Over the last 16 years, I've represented anywhere from solopreneurs to Fortune 500 multinational companies. Clients consistently entrust me to help them identify and remediate risks in their businesses. I've also litigated complex cases in state and federal courts across the country and have developed a keen eye for the types of performance gaps that lead to lawsuits. And it's this eye for gaps that led me to discovering what I call the five shifts. I discovered these shifts when I noticed that most established industries have safety standards that guide them. Think about it: cars, electrical appliances, medications, you name it. Almost everything we use has some sort of safety standards that govern the way it's made and even the way it's used. And why? To prevent people from getting hurt. But for the internet, that is not the case. But the internet is no longer a fringe luxury, but it is now a utility, just like electricity. So much of our businesses and day-to-day living is internet based. But there is not yet a universal understanding that safety standards should be applied there too. However, the companies that seem to get this, that is, the cyber safe companies, generally have five things in common. These five things are what I call the shifts. So first, what is a cyber safe business? A cyber safe business is a business that has taken the right steps to safeguard the digital assets under its care. This means protecting the security of all the personal information of individuals and respecting the privacy of the individuals whom the information belongs to. When it comes to personally identifiable information, a cyber safe business addresses both security and privacy, which are actually two sides of the same coin. Nearly every U.S. state has some law that governs how businesses must handle personal information. Your job is to know what those laws are and take the right steps to comply. And yes, there is a right and wrong way to do this. The right way is what regulators in the courts will call quote unquote reasonable. So, what are these reasonable steps? This is where the 5 shifts come in. I believe that all 5 key shifts are required to become cyber safe, and I'm going to walk you through each one of them in this masterclass. So shift number 1, people before profits. This is the shift that governs your ability to safeguard your brand and bottom line. And if leveraged right, can be a key differentiator between you and your competitors. It's about fostering customer loyalty by building trust and transparency. When done right, making this shift can even increase your revenue. People before profits is the foundation to a sustainable data privacy and cyber risk strategy. This concept has everything to do with establishing a culture within your company that puts your people, that is, your employees and customers, at the center of your business strategy. Basically, the people first principle involves adopting a do no harm philosophy where you consider the potential damage your business decisions may have on your customers and employees and in search for a win-win solution. A socially conscious business model like this one is the enterprise framework of today and the future. Companies like Southwest, Costco, and Amazon have already proven that it works. In fact, studies out of Wharton Business School has shown that the stock performance of companies that adopt a principle like this one outperforms their peers by 2 to 3% each year. So how does this people first principle relate to being a cyber safe business? Well, we now live in a digitalized world. So as business owners, we must all upgrade our thinking to match our new reality. Data is an asset. And if you have employees, if your customers are people, regardless of the market you're in, your business is an asset storehouse. Your employee and customer data are assets. In fact, some savvy business people have understood this fact and have already begun mining out the value in these assets and monetizing the data. Usually, when you have an asset that belongs to someone else and you convert it to cash without their permission, that's considered stealing. But what if the asset is data? This here lies the foundation of data privacy law. Who is the real owner of your employee and customer data? Do you own it? Can you do whatever you want with it? Or are you merely a custodian and required to handle it with care? The answer depends on the laws that apply to your business. Nonetheless, when you apply the people before profits principle, your company handles your customer and employee data with care. You do this because you understand that the alternative may violate their trust or cause them significant harm if their data gets into the wrong hands. Let's take a look at some examples. Let's take a look at the Facebook Cambridge Analytica data breach incident. A few years ago, a researcher put together a Facebook personality quiz that asked participants to download an app and give him access to their friends' data. About 270,000 people consented. But this led to over 50 million people's profiles being scraped for information. The researcher then gave the data to Cambridge Analytica, who used it to build profiles, which it sold to its clients as political research. When news of this privacy breach came out, Facebook lost $119 billion in market value. Facebook was also fined £500,000 or $663,000 by the United Kingdom. And Facebook still faces a potential billion-dollar federal fine in US. Now, if Facebook had just put people first, They would have implemented a privacy by design model, which would not have permitted any data sharing without the person's explicit consent. Let's take a look at another case study. Bayview Solutions LLC is a debt collector that was selling its debt portfolio by uploading entire files of unredacted consumer information onto a debt brokerage website. In an attempt to sell consumer debt, the company posted documents online containing consumers' names, addresses, credit card numbers, bank account numbers, social security numbers, and amounts owed. Over 28,000 consumers were affected. The FTC sued them in federal court and won. The company was ordered to inform all the consumers affected that their data was compromised. They were also ordered to establish and maintain a data security program that must be audited every 2 years by a certified third party. I don't know. Maybe Bayview thought time is money and it's so much easier to just post the information online rather than taking the time to encrypt it or redact the confidential information. It is estimated that the cost of resolving a breach is over $250 a record. So for this business, not putting 28,000 people first likely cost them well over $2.8 million. As we can see, putting people first is not just the right thing to do, it's a business imperative. Failing to adopt this principle in handling personal data may result in serious business losses. Making the shift to the people first making the shift to a people first business model starts with a management decision that is continuously enforced. This involves weaving privacy by design and cyber safety into the fabric of everything your company does, into every business decision, every policy, every procedure, so that it becomes your business culture. Bottom line, if you want customers who are fiercely loyal, make sure your brand is one they can trust. Put your people first. Shift number 2. Know thyself and your landscape. Being a cyber safe business hinges on your ability to safeguard the digital assets under your care. This includes customer data like their email addresses, account passwords, credit card numbers, health info, social security numbers, purchase history, and the like. A cyber-safe business also plays by the rules, abiding by the data laws of every place it does business. So to be a cyber-safe business, you must know thyself. That is, understanding all your business processes, knowing how sensitive data flows through your organization, where it's stored. Is it somewhere in the cloud on a vendor's servers? Or is it on an employee's cell phone? Now, why is this important? Because you can't safeguard what you don't know you have. You must also know your landscape. This means business and legal landscape. What laws govern data in the places you do business? In these days, that may end up affecting your business model. For example, the newly enacted California Consumer Privacy Act may not make ad network revenue a viable business model for small companies anymore. It's these kinds of issues that's important for companies to understand. As the old saying goes, ignorance of the law is no excuse. Making this shift is a 3-step approach. It involves 1, you must know your business, 2, you must know your assets, and 3, you must know the law. So step 1, know your business. You must know all the parts of your business that processes personal information, including all your vendors. You will need to truly understand all the business processes. You will need to map out how data flows through your organization, including data stored in the cloud or on online software platforms. You'll need to examine how all your vendors are handling your data too, because you'll need to oversee them closely. Although you can outsource a service, you can never outsource your risk. Let's take a quick look at a case study. Last year, a New Jersey physician group was fined over $400,000 for exposing over 1,600 patient records to the internet. But listen, the doctors group was not the one who directly exposed the records. The medical records were made viewable on the internet due to a server misconfiguration by their transcription service. Nonetheless, the New Jersey Division of Consumer Affairs acting director stated, "Your own cybersecurity is not enough. You must fully vet your vendors for their cybersecurity as well." Lesson here, you can outsource a service, but you can never outsource risk. So you must monitor your vendors because their mess will be your own. Step number 2, know your assets. After you've mapped your business processes, you should have a good understanding of where to find your data. Once you know where your data is located, you can inventory all your business assets that process your personal data. An asset is stuff like your hardware and software, and even includes physical file cabinets as shown in the example here. In your inventory, also document the type of data involved. As this sample asset inventory shows, you can now begin to see where you should be putting data safeguards. Step number 3, know the law. This is the step where you map your legal obligations so that you gain clarity on your data privacy and cybersecurity compliance requirements. So for every place you do business, you identify the law, what types of data obligation it covers, like privacy, cybersecurity, data disposal, or data breach notification. You then summarize the things your organization has to put in place to comply with the law. Also include a checklist to track whether you've implemented the compliance requirement. By using this system, you'll be able to identify the business process changes you'll need to make and keep track of all the moving compliance parts everywhere your business operates. The data laws that apply to your company depends not only on where you do business, but also what you're doing with the data and what industry you're in. There is currently no universal U.S. federal data privacy or cybersecurity law. Instead, we have a hodgepodge of industry-specific federal laws like HIPAA, if you're in the healthcare industry, or Gramm-Leach-Bliley Act, if you're in the financial services industry. But based on all the major data breaches and privacy infractions, that is highly likely to change. There is currently a big push by the big tech giants for a federal data privacy and security law. So it very well may be coming down the pike in the next year or two. You also need to be mindful of the various state data laws. 16 states have very specific data security laws on what you must do to protect personal information. Some state data security laws, like Maryland, for example, apply to businesses even if the business is made up of just you. And at least 32 states and Puerto Rico have enacted data disposal laws that require entities to destroy, dispose, or otherwise make personal information unreadable or undecipherable once you're done with it. In these states, you cannot just throw personal data in the trash can. Also, the Federal Trade Commission is authorized to regulate businesses' data security. An inadequate data security can be deemed an unfair or deceptive trade practice, exposing companies to steep fines and FTC oversight for 20 years. Also, most states have some form of unfair trade practice or consumer protection law. So if a business's inadequate data security caused people harm, depending on the state law in question, a company may be sued by the state attorney general or even their own customers. So let's take a look at another case study. This is the case study of Explore Talent, an online talent search company. The FTC charged this company with violating the Children's Online Privacy Protection Act, COPA, and the FTC's COPA rule. The FTC accused Explore Talent of failing to have a children's privacy notice that notified parents of its information practices. It was also accused of failing to obtain verifiable parental consent prior to collecting or using personal information from children. The company, as a result of the lawsuit, the court ordered Explore Talent to 20 years of mandatory compliance reporting and oversight by the FTC. The company was also ordered to pay a $500,000 civil penalty. Hey, always remember, ignorance of the law is no excuse for non-compliance. The lesson here: when it comes to personal data, it's imperative to know the laws that apply to your business and comply with them. Shift number 3, assess your risk. Know what you stand to lose. To become a cyber-safe business, perfection is not the goal. Being reasonable is. You're not expected to lock down everything so tight that you can't run your business, but you are required to take reasonable measures to safeguard personal information. In order to do that, you have to understand what the risks are in your business practices and the technology that you're using. So how do you do it? How do you do that? You do it with a risk assessment. Know what you stand to lose. Do a risk assessment. Remember the asset inventory we talked about earlier? Well, using it as a guide, identify foreseeable threats to all your assets, then document the threats in a risk assessment document. A risk assessment uses a risk rating that combines the likelihood that a particular threat will exploit a vulnerability in your firm and the impact such event would have on your firm if it occurred. The most commonly used risk rating scale includes high, medium, and low ratings. Under the rating model, those risk events that are the most likely to occur and would have the greatest negative impact on your firm if they did occur would be designated as high risk. When you identify items that are high or medium high risk, you definitely want to address or mitigate them. This would be the step where, based on a clear understanding of the risk, you identify a solution for that risk. That solution is called a control or a safeguard. So you would decide the solutions or controls you will put in place and the cost for putting those controls in place. So if you don't accurately identify your risks and deal with them properly by putting the right safeguards in place, that can lead to a very expensive data breach. And as we have already seen by the different case studies I shared today, a data breach does not have to necessarily come from a hacker. It can come from having an inadequate process in place that causes customer data to be exposed to unauthorized third parties. According to the Ponemons Institute 2018 cost of data breach study, the average cost of a data breach worldwide is $3.9 million. And that's at a cost of about $148 per lost or stolen record. But in the US, companies spent an average of a whopping $258 per record to resolve a malicious or criminal attack. That is a data breach caused by hacking. And worse yet, the average cost worldwide is $408 per healthcare record. So if a healthcare record is breached, it costs $408 per record to resolve the breach. Let's put that in perspective. So let's say a small business experienced a breach that affected 2,500 people. If the breach was due to a loss of some kind at $148 per record, that breach will cost the company $370,000. If the breach was due to hacking, the breach will cost the company about $645,000. And if the breach involved healthcare records, the breach will cost over $1 million. If you're wondering why in the world is it so expensive, it's because of the firestorm that happens after the breach. There's regulatory requirements, PR, engaging outside experts, postal expenses, communication setups, help desk setups, legal expenses, product discounts, identity protection services. Need I say more? To be a cyber safe business, you have to assess your risk, know what you stand to lose, and address it up front. That brings us to shift number 4. Use the secret weapon. Now, everything we have talked about up until this point now they've been building blocks to prepare you to be able to do this right here, to create and implement a rock-solid, risk-based information security plan. Now, this risk-based plan is a legally defensible data privacy and cybersecurity process that will stand up to any regulator, auditor, third-party inspection, and even lawsuit. It incorporates your people before profits principle and your knowledge about your legal obligations, business processes, data assets, and your risk assessment. The plan combines all this knowledge together into one cohesive strategy. This right here is the number one way to prevent data breaches and safeguard your customer and employee information. It's also the number one way to minimize costs and protect your company, even if you do suffer a breach. The plan is technology brand agnostic and is completely customized to your individual business. The general consensus among cyber risk experts is that implementing a comprehensive risk-based information security process is the number one way to safeguard customer information. Most government agencies and trade organizations like FINRA and the American Bar Association recognize this too. In some instances, implementing such a plan is even a regulatory requirement, like under the FTC safeguard rule. So let's take a look at what happens when you do not have a rock solid plan. Let's take a look. Let's talk about the FTC case of Franklin Toyota. Franklin Toyota is a new and used car dealership out of Georgia who offered consumer financing. As an auto dealer, it was regulated by the FTC and required to comply with the FTC's safeguard rule. The safeguards rule requires financial institutions to protect the security, confidentiality, and integrity of customer information by developing a comprehensive written information security program. Well, Franklin Toyota uploaded customers' personal information onto a peer-to-peer network using software installed on a computer connected to the dealership's network. Franklin Franklin ended up exposing over 95,000 consumers' sensitive data, including names, social security numbers, addresses, dates of birth, and driver security numbers. They were all made available to countless numbers of unknown people using the P2P network. That data could have easily been misused to commit identity theft and fraud. The company was charged with violating the FTC safeguard rule because it failed to have a written, comprehensive information security plan. The rationale is that having this plan in place would have prevented someone in the company from installing such software onto the networks and prevented this avoidable breach. The FTC concluded that the dealer failed to comply with the safeguards rule and was ordered to 20 years of FTC compliance oversight, which included security audits every other year. And not to mention the millions involved in addressing the data breach, resolving the case with the FTC, and notifying affected consumers. If the dealership had made all the shifts we've talked about so far, they would have identified the P2P application on their network. They would have assessed the risk and removed it from their network. When you make the shift and use the secret weapon, a rock solid plan, it forces you to do the cyber risk process the right way. But unfortunately, many businesses put the cart before the horse, ignoring the proper process to safeguard their data and just haphazardly piece together technical solutions like encryption, firewalls, and security software. They tend to jump to solutions first without getting a proper diagnosis of what is really needed. It's like waking up with chest pains and then seeing a commercial on TV for bronchitis medicine and going out and buying bronchitis medicine and then calling a surgeon to schedule yourself for triple bypass heart surgery. Now that sounds absolutely ridiculous. It's crazy because how do you even know that chest pains is bronchitis and that the bronchitis medicine would even help? Worse yet, how in the world do you know you need a triple bypass? That's just crazy. But that's exactly what we do with our business when it comes to cybersecurity and privacy. Now, we all know that the right thing to do if you have a health issue is to go to a doctor. The doctor assesses the problem, runs some tests, and then diagnoses the problem. Then, based on the diagnosis, the doctor prescribes a solution. The diagnosis is what determines the treatment plan. This is just how cyber risk works. The diagnosis from a risk assessment, now that's shift number 3, determines what goes into the rock solid plan. Unfortunately, businesses usually jump right to the solution or medicine and never get a professional diagnosis to develop a treatment plan. On the other hand, the right way to do the cyber risk process is by applying all of the shifts I've shared so far: asset inventory, legal review, risk assessments, and then use all of the information gathered to develop your business quote unquote treatment plan. And that's the information security plan. And that plan will instruct which safeguards you put in place and how you craft your policies and procedures. Now, at Ezeagu Law Firm, we mostly use the NIST cybersecurity framework in combination with the FTC safeguards rule. And that's for those companies that don't have to comply with HIPAA or PCI or another framework. But we use those to create a legally defensible information security and privacy plans for our clients. Now, we're unique because we handle the entire cyber risk process for our clients, everything, including legal analysis and risk assessments. They're all done under one roof and protected by the attorney-client privilege. Now, we've covered a lot of ground so far, so let's do a quick recap. At this point, we know in order to have a cyber safe business, we must put people before profits. You got to know your landscape. You have to assess your risk, and you have to implement the secret weapon, a solid information security plan. Now, before we get to the fifth and final shift, I want to give you a heads up that at the very end of this masterclass, I'm going to share some information on how to get started implementing these shifts today. So make sure you stick around until the very end. But for now, let's talk about how to leverage your resources to become cyber safe within a few short weeks. Shift number 5. The final shift is invest in expert help. The great thing about making this shift is that you can leverage other people's knowledge, skills, and systems to get you where you need to go faster without having to hire extra staff. Your company can be positioned in 8 short weeks, what it would normally take you 8 months to achieve on your own. In order to build a sustainable privacy and cyber strategy, you need people on your team with expertise in privacy and cyber law, expertise in having technical knowledge of vulnerabilities and threats, and also having the ability to pull all of these people, all of these pieces together. Why not leverage other people's knowledge and skills and systems to help you get where you need to go faster? Let me ask you, have you ever walked in a foot of fresh snow that has never been walked through yet? It's exhausting. It's exhausting just to walk a couple of feet. It takes all your energy just to take a couple of steps. But when someone has already walked the path, you are just stepping in the footprints that's already been made. This will be what it will feel like to work with experts who build your privacy and cybersecurity process for you. When your steps are easier, then your strides are faster. To cover all your bases in the cyber risk process, you need legal, compliance, privacy, and cyber risk expertise. Hey, it would be unwise to go it alone. So how does this play out in a business? As a rule of thumb, you'll need to invest at least 3% of your annual revenue to establish a cyber program. So let's use, for example, a company with an annual revenue of 1.5 million. So let's say this business experienced a data breach of 1,000 records. It will cost the company about $258,000 to resolve the breach. But let's say the company invested instead in standing up a cybersecurity and privacy program. Based on their annual revenue, the recommended privacy and cyber budget of 3% would be $45,000. Now, it's obvious that $45,000 is not enough budget to hire staff, but it is enough to retain outside help. So if the breach is prevented, that is a cost savings of over $200,000. Now, in the unfortunate instance that the company still suffers a breach despite its best efforts, according to the Ponemah Institute, there is still an estimated cost savings of $14 per record if an incident response plan is already in place. So the overall cost of the breach will be reduced. To sum it up, you need help in determining whether your actions are reasonable. Are your operations aligned with your legal? Are your operations aligned with your legal obligations? More laws with steep penalties are being passed to govern how businesses handle personal data. EU's General Data Protection Regulation, GDPR, California's new privacy law, to name a few. More states are prosecuting data privacy breaches. State attorney generals, including New Jersey, California, Connecticut, Indiana, Maryland, Massachusetts, New York, and North Carolina, have all dedicated more resources and hired more people for the purpose of data breach investigation and enforcement actions. The stakes now could not be higher. So, invest in expert help is a wise choice. Well, today I promised that I will show you the number one way to prevent data breaches and safeguard your customer and employee information. I promised to tell you how to gain clarity on your data privacy and cyber compliance requirements without being bogged down with complicated legalese. I also promise to show you how to transform your business so that all the moving parts comply with the privacy and cybersecurity laws everywhere your business operates. I also promise to talk about how to build a privacy and cybersecurity process that stands up to any regulator, auditor, or third-party inquiry, and how to build a cyber-safe business that adds value to your brand and bottom line. And finally, I promise to show you how to do all of this even if you know nothing about cybersecurity or data privacy. And I did just that. I showed you that in order to have a winning cyber safe strategy, you need to prioritize people, not profits. Know thyself and your landscape, assess your risk, implement a rock solid plan, invest in expert help. These 5 shifts are what it takes to make your business cyber safe. So now you have a choice. You can either take the information I've given you and you can forget all about it. You can keep on winging it and putting together piecemeal band-aid solutions, copying what others have done with no clear idea on whether you're really doing what's right for your customers, putting them at risk of financial ruin and setting your business up for potential data breach. You can continue believing the mirage that since you've outsourced everything, it's no longer your problem and your vendor will handle it. You can keep on turning a blind eye to the fact that the world has changed and the responsibility for safeguarding your client information starts and stops with you. Or if you want clarity, peace of mind, because you have the confidence your business has taken all the right steps, the right way, and is complying with your privacy and cyber obligations, and have a written documentation to prove it. If you want to rest easy knowing your business is doing right by its customers and is truly a trustworthy benefit to their lives rather than a potential source of financial ruin, if that's what you want, then here's what I have for you. My team and I have set aside some time in the next 48 hours to speak personally with you about how you can apply these ideas to your business starting today. Whatever your budget, whatever your biggest challenges are, we've seen it and we know how to overcome it. We will get on the phone with you and for about an hour, and during your attorney consultation, we will work with you to identify some of the privacy and data security laws you must comply with, and we'll craft a step-by-step game plan on how to comply with them. During your call, we'll get you clear on 3 things. the laws you need to comply with, the data assets you need to protect, and a game plan for safeguarding them. The cost? Absolutely free. But here's the catch. This is not for everybody. Here is who it's for. You must have a high volume B2C business. In this case, size does matter. Because of the depth and breadth of our service, it's best suited for businesses that have some degree of scale. You must have a customer-focused mission and vision. We find that those businesses that do not already have this focus will not get the most out of our services because they will need a complete cultural overhaul first. You must be a business with integrity. We may end up uncovering things that are not quite right. Rest assured that your assessments will be attorney-client privileged and protected. However, developing schemes to evade responsibility or to sweep things under the rug are not practices our law firm chooses to engage in. The clients we like to work with have a high degree of integrity and have a customer-focused mission vision. We find that most companies have not done what is necessary to protect their customers, not because they're shisty or don't care, but because they really don't know how. It's these types of businesses we love serving. If that's you, if that sounds like your business, book a session now. You may be wondering, why are we doing this? Well, it's because we love giving back and helping business owners make cyber safer for everyone. Plus, we know that you might want our help to transform your business. If this is something you're interested in, we can discuss that too and explore if it's a good fit for both of us. If not, that's perfectly fine too. You'll still walk away from your consultation with enough information to steer your company in the right direction. So, if you want to book a free consultation with a cyber risk attorney, go to ezeagulaw.com/schedule. ezeagulaw.com/schedule. You can also schedule by clicking on the button that will appear on the side of the screen. When you click the button or go to ezeagulaw.com/schedule, you'll be taken to a calendar with time slots we have available for you to speak with a cyber risk attorney. Select the time most convenient for you. Right after that, you'll be taken to a really short intake form. It shouldn't take you up to 3 minutes to complete. We just need some very basic information to help prep us for your call so that you get the most out of your session. When you're all set, expect a confirmation email and our call on the date and time you selected. So go to ezeagulaw.com/schedule and I'll speak to you very soon.